But about 20 years ago, almost, I was here as a film producer. So that's a long story, and I don't want to bore you with the details, and some of you know the details, but the reason I'm an attorney is because I was a producer. And that usually isn't the case. Usually you have attorneys or agents become producers, but I learned so many lessons because I had a semi-successful film, feature film, as a young filmmaker. And I learned the whole process of distribution, fundraising, investment, contracts, dealing with people, dealing with corrupt people, dealing with overseas distribution, and seeing the changes in the technology really affect the industry, because we were one of the last, I would say, one of the last 35mm, really low budget indie films to be shot. And even when we were choosing to shoot a 35mm film, people were saying to me, you know, people much wiser than me, were saying, 35mm is dying, why aren't you shooting in video? And at that time, it was because I didn't feel that the DPs had the skill sets yet to really capture that filmic feel. I think that probably has changed in the past 20 years. But one of the things that I think is important is not only learning the legalities, which everybody thinks they need to know the legalities, it's knowing the practical realities, because you may be right on the law, but if you can't enforce that law, or you can't prevent the enforcement of that law, it doesn't matter. So what's really important today is, this is an AMA, and after this is going to be a discussion about intellectual property. Really think about how I can help you without providing legal advice, because I can give you legal information, but I cannot, in this open arena, provide legal advice. So think about what it is that you don't know that's confusing for you, but also think about you as a person and your previous qualms perhaps about hiring an attorney or signing a contract. Think about the contract or lack thereof that you've gone through year after year, when in actuality, if you have a quid pro quo for anything, you should have a contract. Because in my opinion, and I explain this in the book I wrote, and can I mention the book? Okay. The name of the book is The Gasp: How to Seize That Aha Moment and Turn It into a Winning Business. And I mentioned this, that a contract is the ultimate form of respect for creatives. It's a meeting of two or more minds. And that means that I think a lot of creatives, a lot of filmmakers, a lot of artists don't give themselves enough self-respect. They don't honor the value of their work. And I'm telling you that the better the contract, the better the outcome, because you and the person on the other side of the table are coming to an agreement. That's why we call them agreements. And I think the first thing you have to get over is this idea that what you're working on is not worth money, because it all has value. So without further ado, who has questions? Okay, I have a question. How many people here have hired an attorney for business or art? Okay.
Business?
What's that?
For any business, yeah.
Yeah, any business or art. Do you mind me asking what it was that prompted you to get to hire an attorney in the first place?
Well, I'm in real estate business. My father was a real estate attorney, so he was my first attorney.
So he was your first attorney, but you didn't shop around?
No,
of course not.
No, but different attorneys have different areas of expertise. He was like, if I was doing something in this business,
right,
like you have expertise in that business,
right?
Real estate, mortgage business, developer,
right.
Different attorneys have different areas of expertise. So you have to find somebody in that area who's familiar with your business.
Yes, but why do you need an attorney? I mean, last year I started off by saying, why do you need a business entity? Why do we have businesses?
Well, you have to have some sort of structure to build your film or business around. So you have to know what type of structure to pick for that best suits your business. And an attorney can give you that, can give you that advice with business contracts. If you don't know what you're doing in a contract, you can get, taken advantage of or miss an opportunity that you don't know about, or somebody who doesn't have experience in that field, would know about. So
that's absolutely true. Why do you need a structured business? Why can't you just go out and build a business without forming an LLC or an S corporation or C? And anybody else who wants to chime in? Yes.
You can. It's not necessarily as I know you can because I did. It's not necessarily a good idea or a smart idea because if you don't have the knowledge that a specific either a business information lawyer or an entertainment lawyer would have to know what is most advantageous, you leave money on the table or you get screwed.
I don't know about the leaving the money on the table. Possibly, although I certainly believe that a good attorney will not only save you money but may make you money by opening your eyes to different possibilities of ways to make money that you hadn't thought of before. But you mentioned or get screwed, and I think this is important because what is it about filmmaking that, let's say, I've represented fine artists. If I'm going to represent a sculptor, it's less likely, unless that sculptor really becomes big, that sculptor is going to form a separate company. Why?
A sculptor, I'm guessing that he doesn't have, it's just him. It's
just him.
There's less liability. You don't have other people working for you that could sue you, or somebody could say you stole their idea, or you had to protect your idea properly, or your script properly. And you don't want to have personal liability. Setting up a legal entity protects you from personal liability.
It can, but very often it doesn't. And this is actually a misunderstanding. How many have formed an LLC? Okay, if somebody, if you tell somebody to go out on the train tracks and that person gets run over by a train, and we've heard that this has happened, this really affected the indie film industry. If you send somebody out on the train tracks, what protection against criminal liability does LLC provide you?
Criminal? None.
What about tortious negligence? None.
None.
LLCs don't exist to protect you from negligence. And so the liability is really financial liability. And so now understand that if somebody is dealing almost entirely with a company and they don't realize that that you're truly connected to that company, they may not make the leap of going to you, suing you personally for something financial anyhow. But this is one of the reasons why we carry insurance in addition to having attorneys. And so I always recommend to all of my clients, for any business that involves anybody else, it's not enough to involve an attorney. You need to get an accountant, you need to get an insurance policy, and it depends on what type of insurance policy. I'm sure a lot of you have heard of E&O insurance, and now is not generally the time to get E&O insurance, even though you read filmmakers need errors and omissions insurance. Well, at a certain point in time, they may need to, but errors and omissions insurance is very expensive. So what can you do practically? Let's get back to the practical reality. What do you think you could do to avoid going to buying errors and omissions insurance, but still have something where you feel relatively comfortable with your script and with your film passing muster for issues of infringement of intellectual property rights or rights of publicity, rights of privacy, that kind of thing, which is what errors and omissions insurance is meant to cover. What do you think would be a good move to make to spend the money on long before seeking out errors and omissions insurance?
Having an LLC to limit what they can go with? No?
Nope.
Ah.
Nope. The LLC is not going to protect you. I don't think it will.
S-corp?
No, I wouldn't. I'm not talking about a business entity. A business entity is not going to protect you from that kind of liability.
Is there some kind of connection between that and severability in a contract? Not really.
No.
Okay.
Title clearance?
Title clearance. I would go to a title clearance house or an attorney and get an attorney opinion letter. Now, getting an attorney to clear a script is going to be very costly. I don't do it. My counsel in California does it, and he's going to charge you an arm and a leg to do it.
How much? Sorry.
Thousands.
Thousands.
It
Yes.
does save you on the E&O.
It does save you on the E&O because you're actually getting an attorney's opinion.
Can you tell me more about this title clearance thing?
Yeah.
Sure. One was called Act 1. God, I can't even remember the names of the different title clearance houses. But basically, they will go through, you pay them to go through with a fine-tooth comb your script. Or if you've shot the film already, you pay them to go through and identify any areas of potential liability. If you have an attorney opinion letter, the attorney will say, I think you're good for distribution, and that's usually enough to get your E&O, and perhaps at a lower rate. But that's what I would advise in terms, and this is not legal advice, but this is practical advice in terms of if you are worried about questions of that you're just not good at identifying areas of liability, which you should be worried because that's not your expertise. And by the way, attorneys, any attorney who tells you that he or she is an expert in a field is actually breaking ethical rules. And it's very easy for an attorney to call him or herself an expert, but we're actually not allowed to. But so I can't tell you what my expertise is. I can tell you what my areas of focus are and are not. And I don't do attorney opinion letters, so that's not one of my areas of focus. So
you get, I'm sorry.
Yes, please.
I wasn't following really. So you get the title, if you form the LLC, that protects you somewhat. It's almost like a cover. Like they think, oh, well, I'm not going to, if they don't know. Right? Is that what you said? Because it really doesn't protect you personally.
So, right, it does not. It does not protect you personally from tortious, from claims of tortious acts,
Okay.
and that means torts. So negligence or intentional torts, such as intentional infliction of emotional distress or assault.
Okay.
These are civil acts that are torts. Personal injury, that's tort law.
Okay.
You will not be protected there. Now, I'll give you an example of somebody who has spoken about this as a public speaker, and his accountant spoke about this, which I question why he had his accountant speak about this, but he gave public speeches. He was a motivational speaker, and he would go all over go on the road, and there'd be these big events, and he got liability insurance, but he did not get liability insurance for the load-in day, and so somebody got seriously injured on the load-in day, and he was forced to shut down. So understand that insurance companies are not a panacea necessarily either. You have to make sure that everybody who needs to be covered is covered by the insurance on the days they need to be covered by the insurance. But that company had to go bankrupt. And unfortunately, because he did not distribute the assets of the company, so I'll give you an example. I very often, with a number of my clients, have them set up a separate company that holds their intellectual property assets. Because if, God forbid, you have a production and somebody gets injured on that production, and this is why people have the LLC, then you can shut down that company. It's not ideal, but only that company dies. The intellectual property, which was not an asset, it was licensed to the production. The intellectual property is not an asset of the production company, the LLC, and so therefore is not reachable financially in bankruptcy. So there are ways that an LLC will protect your assets and will protect your personal assets. People can't just go after you because they're owed money by the LLC, for instance. Yes?
So if the assets, okay, so I have 2 LLCs, my regular one for my company in general, which I've done most of my shorts under there, and then the Only Woman in the World LLC for my feature. But the script, isn't that an asset of the Only Woman in the World LLC, or can I move it to?
So, if I were structuring it, I mean, the way I would structure it would be the main production company that everything comes from would be an S corporation generally. Now, understand that an accountant may say, you're making $250,000, you should be forming a C corporation, and you should always talk to an accountant. But if you're not, in general, an S corporation may be all you need for the underlying production company that produces all the intellectual property, that owns all the intellectual property, and then licenses it to each LLC that is the production. The reason we have LLCs for productions, and by the way, LLC in New York is horrible. I'm sure you all gone through this, where you have these stupid publishing requirements, publication requirements, that don't exist in any other state. But on the other hand, my counsel complains to me about the business entities in California because they're structured differently, every state. So now, let's step back into what LLCs are. LLCs are functions of the state. And every state has the LLC format. In New York, it started in 1994. My first production company was an LLC, and it was 5 years old when I formed it. The LLC format was only 5 years old at the time. LLCs are not recognized by the IRS. They are recognized by the state. So when you apply for an EIN, an employment ID number, they ask you if you're an LLC, but then they ask you what you want to be recognized by the tax, the federal taxing in Internal Revenue Service, which will say either if it's just you can be a disregarded entity. It's as if the LLC doesn't exist. Or you could be taxed as a partnership, which I, as an attorney, I've never advised, let's put it this way, I've never advised the client, and maybe one of you will shock me one day, I've never advised the client to form a partnership. But you can be taxed by the IRS as a partnership having an LLC, and your tax advisor will tell you whether that's advantageous. And you can also be taxed either as an S corporation or as a C corporation. This is something I don't know that it's usually well explained. I'm hoping I'm explaining it well, but the LLC is just a function of the state. The thing about an LLC in New York is that it costs different amounts depending on what county you're in. And any accountant or attorney who advises you to form an LLC somewhere upstate where you've never been and you have no connections to is being unethical, in my opinion.
Well, I won't go to Delaware because it's really cheap in Delaware. I said, yeah, but I'm not in Delaware.
So Delaware is a different situation. but most people who form corporations in Delaware, and then they come to me and I said, why did you do that? Because you're still going to be taxed by New York if you're doing business in New York. Most people don't realize that. They read somewhere that startups need to be Delaware C corporations, and unfortunately, there's a strong likelihood that you won't go anywhere financially for a very long time, and you're just draining your bank account unnecessarily. So usually with a small production company that produced a number of small films, even though I hate how much you get charged for publication, because it gets to be about $1,000 per LLC. 5? Okay, you really should have talked to
I
me
have 2
first.
publications, so I'll send them to you.
Okay.
The cheapest ones.
Oh man, okay. Now New York City is the worst by far. I mean, I think because you have to publish in the New York Law Journal. But in any event, I would form an LLC for each production, and that has to do with the way you structure the voting structure. Lawyers love LLCs. Accountants hate them, I think. They love LLCs because they're so flexible. You can have, this person gets 60% of voting rights, but 30% of disbursement after XYZ happens. I mean, they're really wonderfully flexible. And a lot of people think that they're going to get investment. That's another word that I generally don't want to hear from people. Because when people come to me and say, I've got my investors, I ask them, what did you do to make sure that you're not running afoul of securities laws? Most people think they have investors and they're really doing something illegal. When you have an investment transaction, guess what? That's an exchange of securities, and there are different rules for that. So now that's different than founding a company. That's not an investment. So if 3 people decide to form a company, and one person brings contributes $1,000, another person contributes $3,000, another person contributes $5,000, and you're thinking of each of these people as founders and investors, get the word investor out of your mind. Instead, think of them as providing a capital contribution to the formation of the company, and set up the structure of reimbursement when money comes in. But to actually seek out investment without going through the proper channels, including getting SEC exemptions and exemptions from the state if you're in New York, is very dangerous indeed. Yes?
That was leading into we just had talked about investor agreements in the last one, and
from non-attorneys?
no, she just rattled off what she
Okay.
had to do, what you had to do.
Okay.
It wasn't like giving us legal advice, but what does, I mean, the things that she talked about were like, the operating agreement we have with an LLC, right?
Right.
So, and that's
As the
what you're
bylaws
talking
of a
about.
corporation.
Right, and that's what you're talking about as far as who gets what and when they get feedback
Yes.
from the partners putting it in.
Yes, but they're not partners, they're members, right?
Members
Yes.
putting it in, right.
Yes.
She also mentioned a subscription.
Questionnaire.
A subscription agreement.
Yes, that's a subscription questionnaire. That's when you are actually seeking out investment.
Right, and those, and also a
Accredited.
profit agreement, she said.
I'm sorry?
A profit agreement? That's something she always gets too.
I'm not sure what that is.
Is,
Profit sharing agreement.
Profit sharing, okay, profit sharing agreement.
oh, okay. I have questions from one of my partners, he's from the business side, so
Okay.
he sent me these questions for a meeting that I'm supposed to follow up on with
Sure.
them. But I thought maybe I'll ask you. He's how much does this cost? Like all the SEC costs to get all of this in order for investments. Like if we're asking for
Right.
$1 million.
So, and that's the thing, is that it may not be worth it. And generally so I actually sought out investors for my
Right.
production.
Yeah.
And there is an SEC exemption, so it's really about what the attorney will draft, but also who you're going to. Because generally you're creating what I would never just rely on a subscription questionnaire. I would have a full-blown, what is known as a private placement memorandum. And a private placement memorandum is going to cost you $5,000 to $10,000. And that is your business plan, plus your operating agreements, plus your subscription questionnaire, plus all these things that you're dealing with people generally who are accredited investors. Now, there are new rules that came out, they were passed in 2012, I believe they finally went into effect in 2015. Most attorneys I know still would rather just deal with accredited investors who basically are worth $1 million or more. But I would never just, subscription questionnaire is just questions. And I would not ever just rely on the subscription questionnaire. I would also rely on this private placement memorandum that has potential financials. If you have a financial history, it talks about all the people involved in the project, any assets of the company, and projections. If you can make them honestly and fairly, because hopefully your attorney is going to be upfront. So, for instance, this is what I would never want to see, and I saw a ton of, especially in the 90s, which is my big fat Greek wedding made XYZ, so there's a good chance that I'm going to make XYZ, or even half of it or a quarter of it. It doesn't work that way. So having the nuance within this private placement memorandum and being honest, and also it also contains okay, so each state has something known as blue sky laws. Have you guys heard of blue sky laws? No. So you have a requirement. In New York, we have blue sky laws. What it is you're not allowed to make just these crazy promises, and there are written out disclaimers for each state that go into one of these private placement memoranda. So you'll have about 30 pages of just, Alaska, from investors from Alaska, and it's in big bold print. But you're telling people, especially when it comes to film, like, this is an enormously risky enterprise. Do not expect to make any money.
Right.
Don't. It's just, this is not the endeavor to think about. If you're thinking about making money, there are much easier ways of making money. And I could not advise you on that because, unfortunately, my heart is with film. But that being said, actually, I probably could. Tech is probably a good way to go. And what I would say is integrating technology and entertainment is actually served a lot of people very well. I don't know if you heard this week that I think the budget this year for Netflix is $12 billion. It's just, there is such a demand for what people call content, and I like to call art, that you can, by being creative, but creative in an entrepreneurial sense, not just in an artistic sense. I think there are ways of making money, but generally, and even when I was a film producer, I had integrated my film company with something that actually went through the roof. This was 1999, so this is a long time ago. But 1999, it was shortly after what was that stupid horror movie that?
Oh,
Blair Witch Project, right? Okay, terrible. I mean, but a phenomenal integration of the new technology of the internet and creating. In the music industry, they call it the 360 deal. It's just a 360 experience involving the music and these behind-the-scenes documentaries. And so we wanted to do something like that. So we had formed a website, and this website was called Cast Our Movie, castourmovie.com. And we invited the internet audience to choose 4 of the stars of our film. And back then, Yahoo was the big website, and at Yahoo Internet Life, the winners were announced. And we were in U.S. News and World Report, Time Magazine, Entertainment Weekly. Everybody was all over this because this was before American Idol, and it actually led to us getting our bigger Hollywood stars because of all the attention we had. We were asked by talk show hosts who we imagined in these roles, and that's how we ended up getting the script to those actors. But if you're just going to rely on your skills and not, unfortunately, or fortunately, your originality, you probably are not going to make money on your project because, unfortunately, quality is generally not enough. It's building a brand, it's building an identity, it's really giving that comprehensive, holistic experience of who you are and your perspective on the world. From my, and now this is obviously not a legal opinion, but my own personal opinion.
Back to that, like investor, you call it investor's package?
I would call it a private placement memorandum with a subscription questionnaire. That's generally what
okay. And then, but what all the, can you list all of the things you would need in order to go into a meeting and ask somebody for $1 million? Like legally, like for like the SEC stuff and.
Yeah, this is almost entirely based on your lawyer.
Okay.
So.
What would you, in your opinion?
Well, so first of all, the thing to keep in mind with a private placement memorandum and generally private fundraising,
Right.
excuse me, is that it's private. And so you can't just shout out to the world, I'm looking to raise millions of dollars, who wants to invest?
No, you're sitting down with someone.
Right. And you're handing them this private placement memorandum
Right.
that's numbered and it's only theirs. So you don't have to.
Each investor
Yes,
is
for
different.
each, it's tailored, it's numbered, and it's
Okay.
for that. Now, there's something else known as convertible notes. Have you heard of convertible notes? This is something in the tech industry. And the concept of convertible notes is that people are making loans that after a certain time period will be turned into equity in a company. And so that may be a stopgap. This is something very popular in Silicon Valley because you give favoritism to the people investing who are potentially investing, and if that loan becomes equity in the company, meaning you found enough people to give you this loan, that would then turn into equity in this new LLC that comes with the private placement memorandum and a certain formula for ownership.
So is that something that if you're like, I don't have anything, like I have no
Yes.
money, that's why you would do it? You would say,
Yes.
okay, let's do it this way then.
Yes. So and generally they're lower. So for instance, if somebody is buying units in a, you want to raise money for, let's say you want to raise $2 to $3 million, and you have 50 or you have $100,000 units. And people say, well, what do you have to show for it? And you say, I have nothing. You might find yourself, and still could potentially, and there's debate over this, but I think it's still a security, even if it's a loan.
Yeah. Okay.
But you may be raising $10,000 notes that can convert from debt to equity in, let's say, a year and a half.
Okay, and you recommend that to your clients?
I don't necessarily. It
Just
depends on the
depends on the
situation.
Right.
That's a popular thing, especially in the tech world.
Right.
I know that Mark Jacobson has spoken here before and has spoken a lot about tax credits. And I got to tell you, when I was a film producer, we didn't have tax credits, and so I know certainly a lot less about that than Mark does. I also have, I generally have fewer filmmaker clients. I have a lot more tech and music and retail or online e-commerce clients than filmmakers. So I don't know how that would work, if that would be necessarily beneficial, but I would like to think that you are all thinking not just about the movie theater, but making the movie theater an integral part of the entire package and the entire experience that you're creating, and the film festival circuit and everything else. But understand that it's not the way it was, where you made a film, you maxed out your credit cards, you shot in Super 16, you had it, enter positive, enter negative, and turn it into a 35 for a print for showing it at film festivals, get it all scratched up, and then hope that somebody loves it. And I think there is no one set path now, and I think that this becomes integral because I think people still love to go to the movies and go have that collective experience, but I think that collective experience needs to give birth to another collective experience.
Mike, I just want to talk, I want to bring it back almost to the LLC, but I want to talk about liability.
Yes.
Because people pull the theater and they want to film in the theater. And I always say, well, you have to have insurance.
Right.
Because we don't employ these people.
Right.
And then they run away. They don't, half of them don't come.
Right.
But the reality is insurance is important.
Absolutely.
So if you could talk to them about, I mean, from a point of view of myself, now we, years ago, we put on a show, and the girl said, well, I'm an LLC, I don't need insurance. No, you do need insurance.
Right.
You're just not now insuring me.
Right, exactly.
So when they go into a place, please educate them on the fact that they do need insurance. Because we're not employing these people, we know who they're bringing in, they could trip and fall, we want to make sure.
Every location, every actor, every crew member, every place, every item has got to be insured.
Now, let me ask you.
Yes.
So they form an LLC, I guess they're protected from their private, but how are their investors protected?
They're not protected. So their investors they are protected from their investors. That's mainly the function of an LLC.
So if somebody, say there's 5 investors in a film, but they're just investors, and then somebody trips on the set, hurts themselves, a good lawyer is going to go after those investors as well.
So this is one of the things, I don't mean to get political here, but one of the things that our president is known for are all these LLCs, especially in New York. I can tell you that one of the reasons that an LLC is chosen as an investment in vehicle is because corporations can be they can be investors within, they can be members of an LLC. So for instance, my primary investor in Returning Mickey Stern, which was here, was an LLC consisting of 16 individual investors who I have no idea who they are.
So they would never be involved in a lawsuit if something happened on set.
Because the LLC would be, because nobody knows who they are.
Okay, all right.
Does that make sense? So it was an LLC that was investing in an LLC. And that happens all the time, and that's something that the Trump organization has been very good about. Their legal team have been aware of this. I think of it as a loophole, and I don't think it's in every state, but certainly in New York.
So a filmmaker who is filming wants to protect their investors should form an LLC to protect their investors, but they should also get insurance.
Absolutely, 100%. And by the way, I'll bring it back to the Greg Allman movie. It was Midnight something. Jim, do you remember the name of it?
I
The one where Sarah Jones, Midnight?
No, not Midnight
No.
Rider. It was something like that.
Right. And it was a movie, it was a biopic of Greg Allman, and a camera assistant was hit by a train. And the director went to jail. And he went to jail because his wife was the producer, and I think he wanted his wife, at least one of them, to stay out of jail and be with the kids. It's serious stuff. You cannot be protected by from criminal liability by an LLC, and even certain, and you cannot be protected by an LLC for tortious acts. But even when it comes to insurance, you have to be very careful. Now, I actually have done in the past. I was a trial attorney, and I did malpractice work. Now, malpractice is another word for negligence. And malpractice, doctors and lawyers, very often they take out malpractice insurance. Malpractice insurance doesn't protect against intentional acts. So if a doctor stabs you, that doctor's insurance company is going to do what is known as disclaiming, and will disclaim that claim because it was an intentional tort, even if it doesn't count as a criminal act, and therefore the insurance does not cover. Very often you will find that you have to read that policy very closely, because if one of your crew members does something reckless, and our production had tons of golf carts, and golf carts went missing, but if one of my crew members drove a golf cart off the pier in a drunken stupor, I'd be pretty sure that the insurance policy, the insurance provider or carrier would try to disclaim, saying that was an intentional tortious act that was not covered under the policy. So you have to read that policy. It's not enough to get the policy. You have to know what you're covered for and what you're not covered for.
Can you recommend an insurance company that does that?
I can't. But I know that
Find them.
there are brokers, but there are all, if you look up specifically production insurance, that's a good place to start, because a lot of companies don't want to. And by the way, this is the same thing as, in just a second, this is the same thing as an attorney. People have got to be a lot more choosy about their attorneys. We're not all alike. Most of us are very different and have our areas of focus. We can do almost anything. We have, technically, because we passed the bar, we have the competence to do it, but let's be realistic, most of us don't have the experience. Don't ever come to me for real estate advice. It's just, even though I actually have hired plenty of real estate attorneys, I would never provide that guidance. And it's the same thing with doing your research. I can tell you that when I was shopping around for an attorney and asking questions, it drove me nuts how often the attorneys would want to read my script. And I hired the first attorney who had experience producing film and Broadway, and said, I have no interest in reading your script. That has no impact on the level of, on the quality of legal services I'm going to provide to you. Now, I actually know a number of entertainment attorneys in California who would disagree with me, because in a sense that if you have something so horrible, something that's really going to be offensive or just cause mayhem or potential liabilities, and it involves let's say it's Jackass. Well, I understand that, because then an attorney may want to protect him or herself from liability, because conceivably they could get drawn into it. But usually I think you should be seeking out, knowing what questions to ask, and ultimately determining their level of experience. I think most people avoid attorneys because they think it's going to cost too much, and maybe it will, but I think that the cost of not going to attorneys is much, much greater.
I have a two-part question.
Yes.
Sort of to answer your question, but to make sure I'm doing this all right. There's this co-op kind of company called Fractured Atlas, where you can actually get insurance through them.
Yes.
And they get you discounted insurance because the insurance companies were actually making a deal with them as a whole, with
Yes.
a number of artists under them, like almost like an umbrella.
They do theater too, right?
Yes.
I represented a theater company that used them.
Okay.
We were very happy with them.
Yeah, I'm very happy with them. We've used them for years. But one option that they did provide, which I got because I felt like it was something that was good for us, was volunteer insurance, which the theory of it, from my understanding, is that the company, the liability insurance will cover you towards a certain deductible. And this volunteer insurance is actually covering what's below that the deductible. And sort of anybody who's on your shoot as a volunteer, as an intern, anybody who's quote unquote volunteering their
All right,
time.
so I'm going to interrupt you right there.
Yeah, explain that to me.
You all know, you know that this is a real concern, and I even there's an old article that I think I shared in past years. I didn't bring it this year. It's your production. That production intern is probably illegal.
Okay.
And you have to be very careful with the concept of volunteers. Now, if it's a nonprofit, that's one thing. But if it's for-profit and you're claiming volunteers, and I get into arguments about it with people all the time, and this is not just film. This is everywhere. This is online stuff, and in general, interns or unpaid interns and volunteers are illegal.
Okay.
Now I know it happens, but you've got to be very careful about it, and there are specific rules. And so this is actually when it comes to creative enterprises, the question of interns versus employees is a very popular issue, and the other popular issue is the question of independent contractors versus employees.
Right.
And now I'm also knee-deep in exploring the questions of inadvertent franchises. God willing, you should create something so good that you want to share it with other parts of the country. If you ask for money rather than you give money, you're probably forming a franchise, and you're subject to federal and state franchise laws and rules. So most people don't realize that, and they create these inadvertent, especially with, and the FTC has all these FAQs on multi-level marketing and business opportunities. I'm sure you've heard of all these things. The Amways versus Mary Kay, Beachbody, I think, does that too. Like you have to. There are specific rules for every financial decision you make, and most people don't even bother checking. When you're not paying somebody, generally, you're breaking the law.
I was just thinking when it came to like when my best friend from high school comes down for one day to help on set and is helping cater, or that one person that just kind of comes down for a day to lend a hand.
And I'm, as an attorney,
that doesn't even happen.
It doesn't matter to me.
Right.
That's an easy way to break up a friendship.
Right.
I don't know. I mean, my job is to help you sleep better at night and to mitigate risk, not to eliminate it.
Does protection apply to that? What is that volunteer insurance that they?
That's why I'm unfamiliar with volunteer insurance, and because I would never advise somebody to have volunteers if they are if they're in a for-profit enterprise.
Okay.
I would also add that you need to be careful, because I advise not-for-profit boards, and the same issue comes up with the volunteer aspect, and I continually tell them, if you are controlling their time by telling them you have to be here at a certain time, now you run awry of not having workers' compensation, which is an even bigger issue, and that's something that, God forbid, you get into and there's a claim against you, you can't even get rid of that with bankruptcy.
And in fact, workers' comp has been applied in New York State to independent contractors if they are in work settings in which they may have been misclassified. Misclassification is a big issue with all companies. There was a Black Swan case involving the movie Black Swan, where I think interns sued and won, but I think it went back and forth. This is not settled law. I think ICM out in California, the interns sued but didn't win. And again, this comes down to a lot of practicality and what people get away with a lot, but when you don't, the thing that is very difficult for me with clients in general, not all clients, but clients in general want me to make something the law when it's not. And I'm always the bearer of bad news about that. But I also recognize, look, when you're talking about enforcement of laws, enforcement of commitments, if you're making a deal with somebody in another country, how are you going to enforce that? Even if you're right on the law. Guess what? And this, I speak from personal experience. I had a DVD deal out with a company in Los Angeles. I never saw a dime. I know we sold thousands of units. I never saw a dime. You know why? Because ultimately I couldn't find an attorney who wanted to take on the case for that low amount. And I wasn't moving out to California to take it on. And so you have to think about, if XYZ happens, what am I going to do to prevent it from happening or to make it happen? Your leverage, your practical leverage, is as important very often as the law.
First of all, I have to say that Michael has been my attorney and he shepherded me through all kinds of things. I'm a first-time filmmaker and I highly endorse him. He's absolutely wonderful. He's kind and he's smart and he knows what he's doing. So, big testimonial for you.
Thank you.
So I know you can't give free legal advice. But, my film is done.
Yes.
I had no insurance for production. It was just basically two of us on the crew. Post-production, I think I'll need E&O insurance. Is there any other kind of liability insurance I will need post-production?
Well, this is, so when you're dealing with now trying to sell your project, it's very often what is demanded by the distributor or the exhibitor. If they don't demand it, then you may not need it. But very often, so I'll give you an example. If you deal with a really high quality sound, post-sound place, they're probably going to ask to be covered because you're going to be using their facilities, and God forbid something should happen. They may ask for liability insurance. It really depends on the demands made, and then again you're weighing the practical realities. Is it worth it for me to spend this money now? That's why I would not, in general, advise. Okay, so I think we've discovered very clearly that when you have leverage and somebody really wants your project, you can make more demands. But if somebody's giving you a 35-page agreement and it's filled with terrible, it's filled with terribly onerous clauses, and clearly they haven't updated their contract since we were only finishing on 35, and maybe since before DVT. If you go through that and redline it, it's going to cost you a fortune. And basically, this is a company that sees you as somebody who didn't retain an attorney. So understand that there are the practical realities of, if you're going to go back and forth with redlining, after a while, you're going to get a sense of if this is a really good deal or not. But most people don't even bother with attorneys. they're DIYers all the way, and so they DIY this, and then they sign the deal, and the deal isn't worth anything because good luck enforcing the deal, and you probably missed something. So, you know, I generally, as some of you know, I charge more for reviewing agreements than drafting agreements, and it used to be reverse. And the reason I do that is because I realized that I trusted myself more than a lot of other people who bring agreements who they say it was drafted by an attorney, and I generally, within a few minutes, I can see that, like, maybe an attorney drafted the original, but you messed with this so much that now I have to go through line by line and see what's missing, what is poorly worded, and it's just 10 times more problematic and just not worth my time. So, so I think ultimately it's on a case-by-case basis, and it's based on how attentive each party is. If that makes sense. All right.
I came for the next panel, but you're still going.
Oh, okay. Any other questions?
What about
crowdfunding?
Crowdfunding. I mean, I've heard that, you know, because you're not giving anything, if you're not an investor.
Well, that's not true anymore, and it's really interesting. Crowdfunding, up until very recently, was known as donation-based crowdfunding.
Yeah.
And that was your Kickstarters, your GoFundMes. There's no difference between Kickstarter and GoFundMe. Except now GoFundMe, for charitable purposes, which is wonderful because I was encouraging people not to use GoFundMe until they made the change to taking 0%, I believe. So they truly are charitable, because people were starting up these GoFundMe for, you know, people who lost their houses, and then like GoFundMe was taking, you know, a certain percentage from these terrible, terrible situations. You know, Kickstarter did the same thing, but it was Kickstarter, and people generally don't take into consideration what the percentage is and how, you know, they don't put that as part of their budget. And what happens if something goes wrong? I read this story, I can't remember if it was a filmmaker or it was just an artist, but one of the rewards was a poster, and there was a misspelling on the poster. So they had to reproduce the poster, and then any money that they made, you know, went to Kickstarter for their 7%. And by the way, Kickstarter is known as a B corporation, and that's a relatively new entity in New York. And I haven't advised anybody to form a B corporation. It's I believe it's benefit. It's B for benefit, and it's like a quasi charitable company. But I, for the life of me, can't see the benefit of forming a B corporation, because the idea is that if you have investors but you're mission oriented, that the investors are not, they're put on notice that they should be expecting profits, if that makes sense. So Kickstarter is a B Corp. But with Kickstarter, you have to reach a certain threshold, and then the money is released to you. Otherwise, the money goes back to the backers, and they're called backers. That's donation-based crowdfunding. Indiegogo has now done donation-based crowdfunding, but they've now branched out, and I think Seed and Spark is still donation-based. But now there is another type of crowdfunding that was approved as part of this 2012 Jobs Act, and that's equity crowdfunding. And I don't know about the success of it yet. I've had clients ask me about it. I can't advise them as to the efficacy of it, but it's the same thing, except instead of backing and giving a donation and getting rewards in return. Which, by the way, I don't know if you heard about this with Facebook and Oculus Rift with their VR. So Oculus Rift is a VR helmet, and they had all these these backers. I think it was on Kickstarter, and they raised millions of dollars, like $15 million, and all these people got these great, first generation helmets, and then Oculus Rift was bought by Facebook, I think, for something like $1 billion, and all these backers were like, well, can't we share in the profits? And no, you can't, because you were a backer, you weren't an investor. Now there's equity crowdfunding, where instead of getting rewards, you get money. You get a percentage. And I believe it's something like you have to testify, and it's through these internet portals that, that they do their due diligence on your income, and it can't be an investment of more than 10% of your net worth or something like
It's
that.
not like selling securities.
That's exactly what it is.
So how can they do that if it's?
That-
They have to do an offering.
They have to. Yes, it's an offering.
Oh, okay,
It's
okay. I thought they were trying to get around. Okay.
No, and that is open to non-millionaires. So there are certain forms of investment that are open to non-millionaires, but one of my attorney friends, who's at a much bigger firm than mine, said to me that those are always the scams. He can always spot the scams because, bless you, because they go after the less sophisticated investor.
You said that the other thing you'll need besides the private placement memorandum is the SEC exemption.
Yes, and it's depending on the state, possibly the state exemption form as well. I believe it's a 90. I can't remember the form, but I think it's something like the Form 90 in New York. But
And those are the CPA would handle those too?
No, an attorney, either a securities attorney or a business corporate attorney, a CPA would handle the tax implications, but you still need to have an attorney, and you definitely should not be going after an offering for sophisticated accredited investors without an attorney, but the attorney would take care of the SEC exemption and the state exemption if there are any. Certain states don't have them, I believe, but New York does.
So those are the three things you need, right? You need
the PPM is part. The PPM, the private placement memorandum, would include the operating agreement,
right,
the business plan, the subscription questionnaire, the list of the assets, the projections. It has all of that included in that.
And so it's $5 to $10 grand to get all ready to go sit in a room with a millionaire.
No, that's $5 to $10 grand to have the paperwork to go sit in the room.
That's what I mean. Yeah, like the pre-production.
Right, but I don't do the work and then introduce you to a millionaire.
No, I'm not saying
great
that
service.
you do that. I'm just saying, that's my
and run from any attorney who says he will.
No. We would find the room.
Right, of course. Yes.
But to prep to go into the room, those are the three things you need, and that would be about $5 to $10 grand.
Yes, I mean I would have supporting documentation. So like if it's going to be a film project, I imagine you may want your sizzle reel or
right.
Okay. In general, like in tech,
like the legal stuff.
Right, but in tech you may even include in the PPM, you may include your pitch deck.
Right.
And the pitch deck is what you're pitching to potential investors. So unfortunately, I think a lot of people choose to pitch to investors without having an understanding of everything involved in investment. And again, because they're avoiding seeking out an attorney.
Right, okay.
You want to also talk about the difference between if somebody happens to have an investor that's a foreign investor versus a U.S. investor? Because that's important. A lot of people might not understand that.
Thankfully for me, I don't deal with foreign investors. But in actuality, I think you're still treated in New York as a foreign investor if you're outside of New York. I could be wrong about that.
Because there's the Reg D and there's the Reg S, so there's a difference between,
right,
the exemptions you get from the SEC.
Right.
Require a different PPM.
Are you an SEC attorney?
compliance background.
Okay.
in the bank. So
Yes.
we dealt with that all the time, our alternative investments, our private placements, and all that kind of stuff.
Right.
So it's important to realize those differences, and also where you're soliciting and where they're signing the papers.
And by the way, and I don't know if this is necessarily applicable to small filmmakers, but like for instance, when I mentioned an S corp versus a C corp, an S corporation cannot have a non-individual investor, and you can have only up to I think 100 or 99 investors. They all have to be in the U.S. There cannot be foreign investors. So you cannot have that same situation as an LLC, where you have an LLC ensconced within another LLC. But with the C corporation, I believe you can. And that's where people are talking about Delaware C corporations. That's when you have people bringing in foreign investors, because you've gotten so much positive feedback. But understand that when it comes to investment, and my wife works for, she's a chief product officer for an Israeli company that is in its post-Series B round. And so the way investment generally is understood in the entrepreneurship space is the seed round, getting that small amount of money to get you started, maybe to bootstrap. That's a popular word. Then there's the pre-Series A, which is a little bit more. Series A, I believe, is 2 to 4 million in general is the raise, and very often preceding the Series A, you will have the convertible notes, the issuing of convertible notes. Series A, and then Series B is in the tens of millions. And then you could have a Series B. And so very often, in order to proceed in each step, you basically have to have clauses that that allow for a buyout and allow for switching to a different type of entity. So essentially the extinguishing of the present entity to go to a bigger and more bloated, but also more valuable to some entity. Did I get that right?
As long as you're talking sort of ballpark figures, what would your sort of ballpark range for establishing a corporation and an LLC for a production be?
I personally would not advise a production to be a corporation.
So I'm saying to establish a production company as a corporation and an LLC, so the two separate, if you wouldn't mind.
I mean, that if somebody came to me at the very beginning stages, I generally would advise that. Mm-hmm. Because if your production company, your general company that's going to hold the intellectual property and it's going to have a telephone and maybe 2 or 3 staffers, but they're in an office and not much happens, that's going to be its own little S corporation, and then it's going to license the IP to the production company, which is an LLC. That's what I would advise. I generally would advise. I'm sure there are other circumstances, and I don't, like I said, I don't want to provide general legal advice because everything is on a case-by-case basis.
Specific.
It is very context specific, but that's generally what I would do.
Oh, I'm sorry. I was asking for the price quote for that. I got that was your advice.
Price quote for me?
Yeah, just 'cause you gave a number for the PPMs.
Yes. Okay, so
yeah.
So actually my rates are on my site.
Oh, perfect.
So I'm very transparent about that, and I believe in transparency. I think that one of the things that's different about me is that I don't charge by the hour. I have my hourly rate listed, but nobody wants it. And so this is known as unbundled services or concierge services. So I've got rates for specific things that I do for companies and people, and then the concierge services is ongoing. It's like an ongoing retainer, but I like to consider it the bat phone. It's anytime you need to talk, anytime you need to get together, and just go over stuff. It's basically a retainer with a lot of added incentives. But I will say this, and I hope this won't sound bad. My rates are very, very competitive, but it's very difficult to serve filmmakers in general for obvious reasons. I think the most obvious is that film as a medium is a very difficult way to try to earn money. And so unless it's part of like this bigger picture that I was talking about, I may not want to get involved, and it's not something personal. It's just that no matter how passionate I am about you as a client, and no matter how passionate I may be about your project, I'm also extremely covetous of my time, energy, emotion, and money. And I love my clients. So it's really difficult for me to, it's a commitment that I don't want to have to fire a client, let's put it that way. And by the way, you should all know that you can always fire an attorney. Always. So now there's actually a client's Bill of Rights. Some attorneys have a link to it in their retainer agreement or their engagement letter. I have it spelled out. You should know what your rights are before engaging with an attorney, any attorney. All right, I think this is it for this, right? Are we moving on to intellectual property? Or? Do you need a break? I don't need a break.
Okay, let's keep going.
All right. So I'm very passionate about intellectual property because I think the law is so fascinating, and the enforcement of the law and the execution of the law and the interpretations of the law, they have no rhyme or reason, and most people don't realize this. And everybody seems to know the words intellectual property, but they don't know what they really involve. So who knows what some examples of intellectual property?
Writing.
What's that? Writing would be, and what would be protected? What kind of intellectual property is writing generally involved with?
The story.
Stories, scripts.
Oh, yeah. Pitch docs, too?
What's that?
Or like pitch docs for, like, if you did a Bible for something?
A Bible, yes. So copyright protects any original work fixed in a tangible medium. And so this, just the very definition, by the way, this is in the Constitution of the United States for copyrights and patents. I don't believe trademarks are. So I just gave you the answer to most of the intellectual property you're going to be dealing with is copyright, trademark, patents, and there's something known as mask works, which and circuits, which you're just never going to deal with. And then there are trade secrets, which your company will definitely have trade secrets, but probably not a film production company. There are also quasi-intellectual property rights that have become the subject, especially for filmmaking. And I did write an ebook that outlines all of this, and this was actually a lecture I gave to the intellectual property section of Nassau County Bar Association, and that's the idea of life story rights, which is actually, they're not rights at all, and they're a big part of filmmaking and writing, and people should be aware of what's involved. But the quasi-intellectual property rights are more in California and Indiana and other states than New York, but this is still applicable to you, and that's the rights of publicity. Have you heard of this term, right of publicity? Right of publicity is generally a famous person, but now sometimes not. And in fact, after Prince died, Minnesota tried to pass a right of publicity that allowed for anybody to have the unfettered right to exploit his or her name, voice, likeness, image, and it's a real thing that you don't think about, but it becomes problematic because it can very much bump up against the First Amendment. Now, to give you an idea, there's a robust right of publicity in California, and when Michael Jackson died, his heirs were taxed millions, tens of millions of dollars for his right of publicity by the IRS because in California you can still have a right to exploit your own likeness or the likeness of one of a decedent that you don't have here in New York. And this right of publicity has affected a lot of celebrities, including Marilyn Monroe. They were trying to establish her residency because if it was in New York, that 7-year itch, the photograph, I think that's what it was. If it were over the subway, yeah. If she died a resident of New York, then the right of publicity would have died with her. But if she died a resident of California, then it still existed. To give you an idea, Robin Williams, when he died, in his will, he donated his right of publicity to Doctors Without Borders for 25 years. So that saved his heirs a lot of money in taxes. So how does this affect the film producer, especially the writer? If you start talking about somebody famous in your film, you can mention them, they become prominent part of your film. You could actually potentially be infringing on that right of publicity. I'll give you an example. There's only been one Supreme Court case that's involved right of publicity. Understand, right of publicity, unlike trademark, even though there is state trademark, trademark is generally federal, and unlike copyright, which is all federal since 1972. Understand that rights of publicity are state to state specific. So there was this case called the Zucchini case, and this is a guy who called himself the Human Cannonball. He was in Ohio, and he shot himself out of a cannon. And Zucchini made a deal with a local filmmaker or I don't know, I think it was a filmmaker or a local television production company to record this and shoot him of him being shot out of the cannon. Well, this seemed to be a pretty newsworthy story, and the local news, represented by the Scripps Network, came and recorded it live. And this went all the way to the Supreme Court. And I actually found the Supreme Court decision on this to be, in my opinion, wrong. But I'm not on the Supreme Court, so it doesn't really matter. But they found specifically about Ohio a right of publicity. So when you're doing something in New York, you may not be as bound by rights of publicity as you are in California. But if you are potentially infringing on the rights of publicity of somebody outside of New York, you have to be very careful. I'll give you a perfect example. This is one of my favorite all-time cases. This involved Vanna White. You guys know Vanna White? Okay. So Vanna White was famous for turning letters, and Samsung was introducing the VCR to the world. And they had a commercial of a robot with a blonde wig turning letters. And Vanna White sued over an infringement of her right of publicity. And she won, because this was California. But I actually wrote an article about this a few years ago. I don't know if you remember, there was a Wheel of Fortune New York lottery scratch-off, and they had a woman turning letters who was brunette. And I was thinking about what her right of publicity would be here, and it wouldn't be nearly as strong. And so, but since it's only New York State, they didn't have much to worry about infringing on her right of publicity. I don't know if the lottery not only made a deal with Wheel of Fortune, but also with Vanna White. And so understand that whenever you're talking about famous people, and sometimes not so famous people, they will make claims of that you did not have the right to exploit their name, likeness, so on and so forth, because they could make money doing that. Now, yes?
What if that person is a convicted felon? Does it matter or no?
So, you're referring to Son of Sam laws?
I guess.
Yeah.
So,
But they're out now. I mean, they're out now, but still, can you talk about their story without, I mean.
so in New York, right of publicity, first of all, dies when you die. So, now Vanna White is not dead, but this is, but there are different, so in New York, your right of publicity really is so narrowly tailored, they don't even call it a right of publicity. It's subsumed into something known as right of privacy. And that's actually only dealing with commercial enterprises. And when they mean commercial, when I say commercial enterprises, I mean literally commercials, advertisements. You know, so to give you an idea, okay, and this is not only right of privacy and publicity. There was this case called the Neighbors case. Has anybody heard about this case of this photographer in New York City who had an extremely long lens and was shooting pictures of his neighbors, including sometimes in partial undress, including kids, like taking pictures from his window of semi-closed and open windows of his neighbors. And he created an art exhibition out of these pieces, and they brought his neighbors brought a lawsuit, and they lost. And the judge said, nothing in the law allows for me, as disgusted as I am about this, to find against him, because this is not a commercial endeavor. It's not for advertising purposes. It was for an art exhibition. So
if you're making a film about a convicted felon and it's that story and whatever, then it's not
the right of publicity in New York, I don't think there is a real right of publicity in New York for the convicted felon. I couldn't tell you necessarily, but in general, we don't deal with rights of publicity in New York. In California, it may be very different. And in fact, Indiana, I think, is the place that most people go to because you can have so I think a lot of famous people sell off their right of publicity to intellectual property companies in Indiana because they're so robust. So it's state to state.
Okay.
Yes.
Is there such a thing, like in music, there's such a thing as public domain, and like in my film, which you're familiar with, I use a Trump quote. Trump is speaking. I never mention the word Trump, but it's his famous quote, and he's speaking it about immigrants. And I looked everywhere, and I was trying, do I need to get permission from ABC, or who owns that quote, or who owns the broadcast of that quote? How do I get their permission? Do I need to get their permission? Is Trump going to sue me? I don't know. So,
well,
how would you address that?
Right. That's the first thing to understand in the United States is you can be sued for anything. Mm-hmm. So the goals obviously are to avoid lawsuits, but sometimes they're inevitable. There's something known as anti-SLAPP. So anti-SLAPP is S-L-A-P-P, I think. No. S-L-A-A-P? I'm not sure. But basically, it's to preserve the First Amendment. And so, again, California has much more robust anti-SLAPP measures than New York does, but New York has a little bit. And the concept is, it goes like this. It's if you are sued for something that really is you're protected by the First Amendment for, and you bring in an anti-SLAPP measure. I think it's strategic lawsuits against, I can't remember what it is. What's that?
Public people, maybe?
No, I can't remember what it is. Public participation, I think, is what it is. But the idea is that if, let's say you're sued for using a quote, and this really is your First Amendment right, there's no good reason, and you bring in an anti-SLAPP measure, a motion to dismiss under anti-SLAPP, and the judge finds that this is outrageous, you should never have been sued, then you can sue. Well, you can collect attorney's fees, and in addition to having it thrown out.
But is that a gray area? I mean, I really tried to find who owns that.
I actually didn't expect to be talking so much about rights of publicity, and because this is about intellectual property, and the first area of intellectual property that I think is most pertinent to all of you is copyright. I don't actually register copyrights for people. You can do it yourself. And I do still think you should do your research on it. But copyright exists inherently in your original work the moment you fix it in a tangible medium. When it's not fixed in a tangible medium, you may have a problem. I'll give you an example. If you, this is actually in the U.S. Copyright Office advisory, if you were to make topiaries, that would not be covered by copyright. Why?
It's not fixed.
Why not?
Because it grows.
It grows, which I actually think is stupid. I actually think that, now, what would be covered by copyright if not the topiary?
A photograph of the topiary.
A photograph of the topiary would be covered by copyright because that is fixed in a tangible medium. There's also something known as fair use, which everybody seems to know, but they really don't, and you've got to be very careful. Did any of you hear about what happened to the U.S. Postal Service this week? Okay.
Oh, the stamp.
Yes. What stamp?
Oh, God. I can't remember, but they made a mistake.
So the U.S. Postal Service, which I actually think that the U.S. Postal Service had a case, but they didn't, apparently, according to this judge. U.S. Postal Service decided to put out a Statue of Liberty stamp.
Yes.
I think they created 4 billion, they sold 4 billion Statue of Liberty Forever stamps. Made $70 million on these stamps. And apparently it wasn't of the Statue of Liberty. It was the Statue of Liberty at New York, and Las Vegas. And the sculptor sued for copyright infringement and won. Because this Statue of Liberty was sexy and sultry. Swear to God, that's what it says in the complaint.
Wow.
So it's very costly to take pictures or record people's original works, and it can be costly for you. Now, I know everybody thinks something that they're doing is fair use. And the problem with fair use is that this is what I mean by no rhyme or reason. There was also a case this week in Virginia where a guy took a picture, I feel like it was columns in a building, whatever it was, it went to a stock photography site. And it was clearly his image, and somebody used it, I believe it was in a brochure, and it was an advertisement, I believe. And he sued, this photographer sued and lost because, in my opinion, the photographer okay, so the judge said it was fair use because it was based on fact, which is, this judge, in my opinion, just had no idea what fair use is. Fair use has been used, has been claimed by so many different people, but this is the thing to keep in mind about fair use, except for one case called Lenz v. Universal. And Lenz v. Universal was the dancing baby case. and this was just resolved in the Ninth Circuit, never went to the U.S. Supreme Court, but did you ever see this video of a mother with a baby that's dancing to a Prince song?
Yeah.
Okay, so this became the subject of a lawsuit that went on for almost a decade. And ultimately, they found that it was fair use, that this mother had Prince playing in the background and it didn't have any effect. But in this case, they said that it's not an affirmative defense, it's inherent. But every other case, it's what is known as an affirmative defense. Does anybody know what an affirmative defense is?
No.
It's your reason for why what you did was okay after you've been sued.
Holy cow.
So, what am I saying here? You cannot apply for fair use. You cannot get a fair use license, or there's no body where you say, hey, I really think this is fair use, don't you agree? And they issue you a fair use certificate. It doesn't work like that. So if you think it's fair use, talk to an attorney, because in my opinion, the presupposition is always that you are infringing, but you got a good reason for it. And sometimes it goes your way, and sometimes it doesn't. But like we said in the beginning of this, the goal is not to get sued in the first place. So, yes.
So Saturday Night Live couldn't possibly get in trouble for all the Trump impersonations that Ellen Baldwin.
So that is part of the fair use doctrine. But what's really interesting is, and I remember I was in law school, there was this guy who wrote the jingle. And it was actually a really good book. He was selling his book, and he wrote the jingle for I Love New York. And this became a seminal case on copyright infringement, because, and I think it's settled out of court, but he sued Saturday Night Live for this Gilda Radner thing where it was parodying the I Love New York song. I can't remember what it was. And I think it's settled, but the judge said that you found originality in 4 notes. Now think about I Love New York. I'm not a singer, but if you were able to identify that. So this was very alarmist for people in the EU recently. I don't know if you heard about this, where people were saying that this new copyright legislation, which did not pass, was going to ban memes. Did you hear about this? Mm-hmm. But the thing is, memes are almost always not fair use. It's just they're not enforced. You're usually infringing, and you probably don't have the necessary fair use. So if somebody did want to bring a lawsuit, it probably would win, in my opinion. I'm just astonished by how much is out there. So now parody is a reason. It could be a factor. The problem is that they haven't determined how much of what. So the 4 factors are the amount and substantiality, the purpose and character. We talk about transformative. Is what you're doing transformative? The economic impact it's having. See, I would argue, by the way, that when it comes to the stamp question, that it's fair use, because what possibility did this sculptor have of licensing the image of the Statue of Liberty to the U.S. Postal Service? I also think that we're going to see virtual and intellectual eminent domain soon. Takings.
What was
Yes.
the first factor you listed for?
The factors are purpose and character, the amount and substantiality used, the economic impact, and now I'm blanking.
Transformative.
Yeah, but transformative is part of the purpose and character. I'm blanking on the 4 factors, and I'm sorry. And I have to get this back in my head because I start teaching in September. Yes.
I stumbled in late, so if you address this, shut me down. Product placement, if you're shooting a film and you have a Jack Daniels bottle that a character finishes and then goes and beats the hell out of his wife in the next room, are you in trouble with Jack Daniels? But the next question is, if the fellow drives off in a Chevy pickup truck, I mean, how much do you have to actually? When do you have to reach out to a company for permission, and when is it okay?
That's the golden question, and unfortunately, I don't have a set answer. You are talking about trademarks, and trademark law is very different from copyright law, and new law seems to be made all the time, and so the difference between copyright and trademark. Does anybody know the difference between copyright and trademark? No. Trademark is used in commerce in specific classes, and it's the brand. It's so you cannot copyright, let's say, a book title. You actually can't even register a trademark for a book title, but you can register a trademark for a series of book titles if it's part of a series. So, for instance, if you write a book, Harry Potter, that's a trademark. That's not a sorry, you would not get the trademark. But if you have Harry Potter and, I didn't read the Harry Potter, but the Prince of what and the Curse of what and
Sorcerer's Stone and
right, suddenly you've got the trademark. And so, so to give you an idea, did you guys hear about this kerfuffle about Mike Pence and John Oliver and the bunny?
Yes.
So Mike Pence has this bunny. It was like a children's book, and he was, on the day he was releasing his children's book, John Oliver, Marlon Bundo, I think is it, right? And so John Oliver released his own Marlon Bundo book that was about a gay bunny, and it outsold Mike Pence's. So Mike Pence then registered a trademark for Marlon Bundo because he was going to be creating a book series, because that first book could not be registered as a trademark. But so he had to have the book series in order to create the trademark and stop John Oliver from using the Marlon Bundo brand.
Who came up with the name Marlon Bundo? Where did that come from?
I think that's the name of his bunny. And Mike Pence's bunny. I could be wrong. So fair use is actually less settled law when it's applied to trademark. I remember. I mean, this is part of the legacy of this willy-nilly culture of approach to filmmaking. So I'll give you an example. I liked your example with the Jack Daniels. Like, I as an attorney would say, please don't do that. And by the way, don't even seek out the license. Why? There's no way in hell Jack Daniels is going to let somebody beat somebody with a Jack Daniels bottle. So the only thing you can hope for is that your film does so miserably nobody sees it to sue you. But that's really what we're dealing with here too, is that ultimately people aren't suing people when they're not successful. They're suing you when you are successful, and hopefully you will be successful. And so please understand that I, as an attorney, am going to advise the most conservative approach to everything. What you get away with is another matter, but trust me, if you did your due diligence when you were a nobody and then you became a somebody, that people are going, the knives are out for the somebody. They always are.
Okay, here's a positive example. The other week we shot a woman getting out of her Mercedes, and she's dressed really nice and she's going shopping. So our DP shot one where you can't see the Mercedes logo, because we're not sure. I mean, we're going to contact them anyway to play nice and say, hey, we'd like to cross promote with you, all that stuff. But if they were to say no, we have a shot where we don't have the Mercedes logo and it's just a woman getting out of a car.
So this is a really interesting situation. Did you talk to an attorney about this?
We have not talked to an attorney yet because we have no budget and the attorney we're working with is not returning our calls.
Okay. I don't know what to say about that, but what I will say is I would doubt that Mercedes is going to be, really proactive with this. Again, they're not interested.
I mean, we still want to get in touch with them.
Right,
before we get out of post.
But to do what? Do you know, like?
To see if there's a clearance, or if we can do something with them later with Mercedes, if we get a budget and it gets bigger and stuff like that.
Yeah. Well, look, it's possible, but they may. So I'll give you an example. If there's somebody smart in the legal department at Mercedes, which I'm sure that's probably the case, but not necessarily. I once dealt with Apple, and it was the worst drafted agreement I've ever seen, and this was a distribution agreement, so you never know. But if they've got somebody smart, what they're going to say is, okay, we will give you the festival license for $1,000, but if this actually gets distributed, we're going to charge you $100,000.
What if we want money from them for showing their product?
Come on. It's not going to happen. I can tell you that. I would lay down money that it's not going to happen.
Unless you're Steven Spielberg.
Right. And even there, just 1 second, I don't want to give anything away, but there was one of my all-time favorite shows is Mad Men. And the season finale had major product placement. And there was no lawsuit. There could have been a lawsuit. It would have been a really interesting fair use question. And in this case, you would have had questions of trademark fair use and copyright fair use because you're including the brand, but you're also including actual footage from a commercial in this episode. I don't know, and that's the problem. There was a Broadway show called Hand of God, where there was a whole lawsuit against by the heirs of Abbott and Costello, and they used virtually the entirety of the Who's on First routine. Now, setting aside the question of whether the heirs owned the rights to Who's on First, because it was in their comedy routine but was also in a movie, and there are also expirations to copyrights. They lost eventually, and now a judge just approved attorney's fees because this judge found it to be a frivolous lawsuit. So understand that if you are going to register a copyright, you register the copyright within 3 months of publication of whatever you're doing, the release of what you're doing. And the registration of a copyright affords you certain protections that just having the inherent copyright doesn't. So if you don't register a copyright and you see somebody using it, you can sue, but you sue for what are known as actual damages, meaning what it's really costing you. And that's very difficult sometimes to ascertain. When you sue somebody who, when you have a registered copyright registration with the U.S. Copyright Office, you're suing for statutory damages, and you are suing potentially for attorney's fees. So, has anybody in this room, because I've had clients come in, has anybody in this room gotten a demand letter from Getty Images? No? Okay, well, if you downloaded an image, you have, okay. How much did you settle for?
It just go.
It just went away? That's remarkable.
Yes.
Because it usually doesn't. And usually you can't claim fair use. And very often it's for something you did 10 years ago because the infringement occurred the minute you downloaded from Google Images, and you saw a really good image and you put it up on your website, and it was then licensed to Getty Images, and they're suing you. They're telling you they will sue you either for they will tell you they're suing you for willful infringement, and each instance of willful infringement is statutory damages of up to $150,000. Now it's like something like $700 for not willful, which is generally around. I think the sweet spot is generally $300 to $700 to settle. Now you can write back to the attorney and say, it's not up on my site anymore. These are the fair use reasons. You may or may not, but this has become a cottage industry by companies who have a legitimate claim according to US copyright law. Now the funny thing is that these companies don't just stop in the US. And this is really interesting because they're going to Australia. I just got an inquiry from Guatemala, from a US citizen in Guatemala who received a demand letter for copyright infringement on her website. You have got to read contracts carefully. And even if you think something's royalty free, doesn't mean you're not engaging in a license. And so you need to read the terms of that license. These are all contracts, and the problem is we are in contract overload. You click, you click I agree. If there is a link before that click agree that's to the terms and conditions that you've agreed to, that's a contract. And you are bound by that contract. Now, if there isn't a link where you can see the agreement, then you may actually win something because that's known as browse wrap rather than click wrap. But yes, but you've got to pay attention to what you click on, and if you think something's royalty free, read the terms of what you can and can't do before you get the license. Do not assume you have a right to use somebody else's copyrighted material.
Question: when it comes to public type meetings, so it's a town hall meeting, some sort of debates going on, you go to a Board of Education meeting, can you take, if you're recording this, whether it's one of the people speaking there, either by audio or video, can you use that freely? What are the rules around that?
So not surprisingly, there are lawsuits related to this too. In fact, there's one, and I don't know the outcome of this, but some guy, I think it was in Peoria, Illinois, and I think he was recording like the municipal town meetings, and then like doing his own version of Mystery Science Theater 3000. And so you didn't just have you had questions of rights of publicity, because conceivably these people could have a right to exploit their own names and likeness. Of course, the question is, would they? But
especially if it's public,
right.
It's sort of those things like if you're out in public, you can take a picture of somebody because you have no right of privacy.
Well, yes, but we're talking. That's a state. Remember, right of publicity and rights of privacy are state, and they differ from state to state, and that's very important. And there are distinctions between the federal government and state governments, and these aren't all well established. So the first thing you should know is that you have no inherent copyright in your own story. And I know that sounded your own life story. So when we were talking earlier about life story rights, they don't really exist. We have contracts, and generally the contracts, you get a lot of agreements. You may get photographs, and you may get this and that, which are protected by copyright. But your inherent story, unless you've recorded it somehow, is not protected by copyright. It may be protected by rights of publicity, depending on the state here. Now, What I would say is that there are even questions about that if there are interviews. So, there was this case involving Sudanese refugees. That there was a movie made with Reese Witherspoon that didn't do very well. But apparently, when these Sudanese refugees were interviewed by the film producers gave them a contract, or maybe they didn't even give them a contract, but they took a lot of their stories and turned them into, you know, parts of the movie. And the judge said that it's conceivable, I don't agree with this judge, by the way, and I think most attorneys don't. It's conceivable that this could be a work of joint authorship because they made a creative contribution with their story. But the thing is that they never recorded their story. So if you interview somebody, up until now, I always thought that it was pretty reasonable to assume that you owned the copyright, maybe not the right of publicity. See, this is what has to be in every clearance. No joint authorship, no right of publicity, no copyright, no trademark, no patent claims, nothing. If they're going to interview with you, if you're going to record them, if they're going to appear in your film, they cannot make a claim. There was an actress, and this is a really horrifying story, and this nearly went to the Supreme Court. Again, this is California, Garcia v. Google. And this woman was an actress, and she was recorded for like 5 minutes. And it was a German director, and the German director dubbed over her performance very inflammatory rhetoric about Muslims. And this was, if you remember the videos with Libya, do you remember the whole Benghazi thing that was supposedly related to the video, the innocence of Muslims? This was it. So this woman, Garcia, got death threats. And she ordered Google to take down the film from Google based on what is known as the DMCA, the Digital Millennium Copyright Act, which, by the way, if you host a site that takes in any user-generated content, you would be wise to get yourself DMCA safe harbor protection by applying to be a registered agent under the U.S. Copyright Office. For $6, you are now treated as a registered agent. You're protected by the DMCA safe harbor, which allows you to not get sued for copyright infringement if you did not knowingly have infringing content on your site. You can pull it down with a DMCA takedown notice. So here she asks Google to take down this clip of her saying all these things that she didn't say, claiming copyright in her own performance, which is considered a moral right in other countries, but not in the US. And Google refused because she did not have a valid copyright claim in her own performance. So actors, if you're an actor, you have a one-person show. I like to use the example of Spalding Gray. Spalding Gray was this wonderful, he called himself a monologist, and he made movies of his monologues. But I saw him perform live, and what he would do is he would have these 2-hour monologues that he did from memory. And he did it from memory from the performance before, so they were never the same. But if he didn't write it down, think about this, if he didn't write it down and I recorded him on the first day, I would own that copyright. I think, as far as I can tell, even though that's his hard work, for the life of me, I cannot figure out a way that somebody performing. So this, who might you think of when I'm talking about a stand-up comic should be writing down that performance? Because look, if it changes, then that's a derivative work, and that's still you have a monopoly over that. That's still yours. So write or record everything that you want to claim a copyright in.
I just want to clarify, the downloaded graphic, the downloaded image, at the time it was not me.
Right.
I kind of like do graphics for a little, to some extent, and but it was my underage daughter. She was 12 or 13 at the time, and
so that's actually.
It had a happy ending, but she also had a whole lot of friends that came over and downloaded music. Yeah. And Cablevision called.
Right.
And it was an issue, but that went away too.
And I've had.
I talk a lot.
No. This is an interesting thing because my of councils in California, we meet via Zoom every week for 2 hours, and we talk about the law, we talk about our practices, and he and I had similar circumstances where he had a client who was underage. It was an actress, and so minors cannot sign legal agreements that are binding.
That's why I went away, yeah.
So then what do? You sign an agreement with the parent, but how do you bind the child when the child reaches majority age? It's not an easy situation. So I actually had a client who this was on me. I didn't think to ask, is the other party 18 yet? Because it didn't even occur to me. This is a music client, and it was somebody who was underage, and I said, honestly, wait till he turns 18. Because the potential for somebody to walk away is high, and what are you going to do to enforce that? And yes, you could bind the parents, but what if they're, the parent cannot control the majority child? It's actually a naughty issue for people who make deals with children.
Right. Actually, it was also, well, on a personal level, she was ready to go to war with everybody because it was for her personal use. I said, yeah, but your personal, Facebook page
Right.
is not personal.
By the way, personal use and fair use are not the same thing.
That's correct.
Never.
Right.
Never.
Right.
You probably don't have a good idea of what is fair use. Now, again, was this actually a Facebook page?
Well, she put it on either
Because-
Instagram or Facebook.
Because I've never heard of infringement suits or demands for social media.
Well, somebody saw it on one of her social media outlets.
But was it tracked to a website afterwards? Because I've only heard of it fixed on a website. I have not heard yet of, because I mean, basically you'd be suing the entire country for use of infringed works. Everybody, I mean, everybody has infringed work. I know I have infringed works, I'm sure of
She
it.
thought that, royalty free, like in her 13-year-old.
So by the way,
thought that it was
just because it's royalty free,
okay.
generally there are certain terms in order to achieve that.
Personal use was permitted, but not in the way that she used it. It
Right.
was very, very public, and
Right.
it was very different.
Yes.
Yeah, it was hard to convince.
I mean, like, YouTube is like a really great line because even like I remember when I was like 12 or 13, like, I mean, like if you bought a song from iTunes, it's like, okay, it's yours, like, or you think it's yours.
It wasn't, it was a license.
Exactly, but I hear a lot of cases where it's like kids will be uploading videos with like a song in the back, and they'll be like, YouTube would threaten to suspend your account, and then you're kind of, so that it's like this whole thing where it's like they kind of terrorize accounts because of all this, but they don't explain why it's wrong to younger people.
Yes, and it's interesting because I taught this course, Intellectual Property and Cutting the Deal, to LIU Brooklyn MFA candidates, and there's a real bright line between, I would say, people under 35 and people over 35 on the concepts of fair use and privacy and things that I think that there's going to be a coming change of acceptability. I could be wrong, but and people my generation and older, people covet privacy and intellectual property protection a lot more, I think, than people who are younger. And I noticed this in teaching my class, in my students, that, now remember what I said about the dancing baby case. Yeah. They found against Universal, they found that in that case, I think it may have even been what is known as de minimis, which is, it was just in the background. YouTube has the ability to, it's called content sense or something like that. Is that right? Content something. And they can follow the sound waves, and if the sound waves match an established song, they pay a license fee for that technology to then take down the video that's including that. But one of the problems here is that the Lens v. Universal case, which really only affects California, required that a takedown notice must actually be from an analysis of whether there was potentially fair use. So conceivably, in my opinion, if you have a computer that just says, take it down, you're not doing that fair use analysis.
Yeah.
Does that make sense?
Yeah.
So what I would advise is, you need to be more cognizant of all the potential copyrighted works, all the trademarks that are potentially in your film. And this goes back to the last conversation where I was talking about title clearance, because ultimately, if you want distribution, you may not get that distribution that you want. Now, there's certain distributors who will just distribute practically anything, but that doesn't mean that they're just taking the risk. I don't know. Now, by the way, I wrote an article a long time ago about Etsy. Are you guys familiar with Etsy?
Yeah.
So Taylor Swift sent a demand letter to Etsy, having all items that said the words "shake it off" removed from Etsy. Now, she didn't have a registered trademark in "shake it off." She did have a registered trademark in "This Sick Beat," which is from the song "Shake It Off." But the thing is that Etsy doesn't want to piss off Taylor Swift. So they comply. And they have the right to, because they're a private company. And so if YouTube wants to pull something, they can. There's nothing stopping, and they're not going to listen to you because you're an individual. You have the right, however, to set up your own company, your own website, your own video streaming service. People have expectations of other platforms, and ultimately, if you want the power, you have to build the platform. And in fact, very often, it's the platform that makes them more money than the content the platform is distributing. We talked about Kickstarter before, YouTube, Etsy. I'm sure Etsy's making a lot more than all the artisans who are posting their wares on Etsy. Any other questions?
Was there anything else that you were going to add about the stand-up and one-person performances?
Just that this idea of fixing in a tangible medium. Okay, so there's one other case that I love that I'm sick of now, and I'm sure some of you have heard about the Monkey Selfie case.
Oh gosh, yeah.
You guys know about this?
No.
Okay, so this photographer in Indonesia was with a bunch of monkeys and had his camera lying around, and apparently the monkey took a picture of himself, and these were phenomenal pictures, and he said, "Look what this monkey took a picture of with my camera." Now, He published it. He became famous, and so did possibly the monkey. But that's actually part of this trial because they couldn't identify which monkey brought the lawsuit. Actually, really, a friend of the monkey. Guess which friend? PETA. PETA, on behalf of the monkey, sued. But this started because Wikimedia put the monkey picture on the site, and the photographer sued, claiming copyright. And the U.S. Copyright Office gave, again, in my opinion, the wrong opinion, gave the opinion that he could not claim copyright. Now, I believe that a creative endeavor is not purely the moment when you click that button or you get that. I think it's the curation is part of that creative process, but the U.S. Copyright Office doesn't agree with me. So they found that it's in the public domain when an animal or a non-human makes. Now this is actually has. I know this sounds crazy, but this has the potential. This line of thinking has the potential to shut down the major studios because, okay, this is another great story. There was a software that was used in every major blockbuster film that was a CGI software that this company made that would create faces and likenesses out of an algorithm. And this was applied to all the CGI of every the Marvel movies. And every big blockbuster used this software, which was bought from a Chinese company that pirated the software from a U.S. company. So the U.S. company is claiming copyright over all of these films, wants them shut down, or wants all the royalties from these films. And it hasn't been thrown out yet, but the main argument against it is a computer designed it, a human did not design those faces, and therefore was not under human control. And this is going to happen again and again. You have, let's say you have a camera and you throw it up in the air and it's on timer and starts recording. Did you take that picture or did the camera? These are cases that are going to, the drone. Wow. You start doing drone photography, at what point does that become public domain because you did not actually control it? And so these are things to think about because the actual human control is becoming the next level of issue for creators. So I would say, as often as possible, be in control of what is created and fixed in a tangible medium.
But don't own your animals.
But you could use that same argument to say any tool like a paintbrush would
I agree with you. But the U.S. Copyright Office may not. All right. Any other questions? All right. Thank you.
Yeah.
You can, you just have to think about it.
Usually to follow.